Imperator and the Roberts Court. Welcome to Law and Society. Please subscribe. Today, I want to talk to you about the United States Supreme Court and what it's doing in creating this presumption of the unitary executive. And although there is nothing that I know of theory of a supreme judiciary, it seems from the Roberts Court that it also believes in the sole authority of the Supreme Court, of itself and the president, but not even the lower courts. So it really is weakening the entire judiciary, because under this approach that we're in, nothing really matters until the case reaches the Supreme Court and the Supreme Court rules on it. Nothing is final until then, and we'll talk later about the sort of the impossibility of that finality because of how they're operating the shadow docket. So it aligns with Donald Trump's imperial, despotic, absolutist view, because Donald Trump has said many, many times that he will not listen to the trial courts and he will appeal all his cases all the way to the Supreme Court. He said that he's going to listen to the Supreme Court, though. But despite him saying outwardly that he will, comply by the Supreme Court, he has complied in certain instances with direct Supreme Court mandates, like stopping that bus of immigrants. But there are many, many instances where his regime has directly defied district court orders and continue to find novel ways to evade the court's orders. Now, it brings to mind, when you say the defiance of district court orders, the Department of Justice has filed a complaint against Judge Boasberg, who presides over a case to see whether the government defied a court order when they ordered the flight and departure of the Venezuelan migrants from the United States to El Salvador, among whom there was Abrego Garcia and Henry Romero and Manuel Gutierrez and 200 more of those people. And Emil Bove, the guy who was in charge of that operation, has just, by the Senate's advice and consent power, been confirmed as an appellate federal judge for the Third Circuit of the United States. And you have to wonder what the state of our judiciary is when on one hand you have the Supreme Court that is aligning and being acquiescent to the executive's power and going about it in a way as to skirt the normal procedure and provide reasoning for their opinions, their unreasoned shadow dockets. And on the other side, you have Emil Bove, who openly said by whistleblower account, by a whistleblower who went by the appropriate channels of whistleblowers and said that Emil Bove said, fuck the courts, when talking about that immigration issue with the El Salvador migrants sent to El Salvador. That's an open defiance. And on one side, the judiciary is gaining people like that who are Donald Trump loyalists and, was Donald Trump's personal attorney at some point. But it's not about qualifications. It's about loyalty to Donald Trump. And on the other side, you see another kind of loyalty to Donald Trump where, the judiciary in the Supreme Court is saying, in belittling the district courts and curbing their jurisdiction and overruling their equitable jurisdiction in favor of Donald Trump's regime, in their shadow docket that's doling out equitable relief without writing opinions or providing a reasoning for why they are siding with Donald Trump's government. And so it becomes even more hazy when you have an injunction order that has been stayed by the Supreme Court that you don't know to what extent the Supreme Court's position is on a certain issue, but the Supreme Court stays an order, denies the injunction to stay an order of the executive, and the harm is being done while the stay is in place. And birthright citizenship is the example where, there's hurt happening, there's irreparable harm on a daily basis if you don't give district courts some sort of discretion in understanding what their jurisdiction is. So now there are 3 different lines of cases in birthright citizenship where you have plaintiffs, if they're individual, that court order only reaching the district. You have a class certification order from New Hampshire, and you have a state protective order for the states of Washington, Illinois, and a few others. And that provides a statewide injunction from the Ninth Circuit Court of Appeals. But what will happen when it gets to the Supreme Court, it remains to be seen. And, going back to corrupting the judiciary, you have that sort of shadowy thing happening, and the aloofness of this Supreme Court to provide reasoning for some very important things, like I said, birthright citizenship and federal employment in cases where they're sidestepping and the substantive issues and going by providing the executive interim equitable relief while the case continues. But in these issues, people are fired. There is actual harm. There's actual monetary harm. And then on the other side, you have this corruption of the judiciary where you see the Senate relenting its advice and consent authority and being responsible by nominating people like Emil Bove to the federal courts, the federal judiciary, and filling it with unqualified January 6th sympathizers, people who say fuck the law, Emil Bove. And it's even more dangerous because it's a lifetime appointment in a federal circuit court of appeals, which has a lot of power, judicially speaking, well, unless the Supreme Court takes it away from them. And it is a bigger failure than the complete failure of Senate to properly vet Donald Trump's cabinet secretaries. Of course, that's a huge blunder. And then there's Congress's rescissions package that relented Congress's spending power. And so that corruption is happening on the side. But today I wanted to talk to you about the all sides sort of corruption of the judiciary coming from the Roberts court, and also we're seeing it encroached upon by congressional assent to presidents' highly corrupted, unvetted, irresponsible picks to the federal judiciary. And you can't help but note that it is all happening under Chief Justice Roberts' watch. You know, how Justice Roberts doesn't see this happening and as a threat to the judiciary and the judicial branch, I don't know. Perhaps he also believes that only laws that matter are the ones that are adjudicated by the Supreme Court. And even those don't matter anymore. Because if you look at Chief Justice Roberts' legacy, that starts out with Citizens United, that essentially held that corporations are people and they can make contributions and have independent political organizations that are now called PACs, where PACs can give millions and millions of dollars to political candidates. And that's blown up the amount of money that goes into elections, that is corrupted elections in a way as to making our federal elections, whether it be House of Representatives or Senate or the presidency, has become a gladiatorial game for the multi-billionaires and the multi-millionaires. And so it's become a game. And we are seeing the impact of that. Soon after the Citizens United, there was the wave of the conservative movement, Tea Party, coming in, and you see the sort of erosion of how elections were conducted. Then the manner of truth changes with Donald Trump, you know, and now we live in sort of a post-truth society where we are flailing in the wind, and the federal courts the district courts are doing their best to hold the ground through presidential law in interpreting the way the Supreme Court is also throwing them these curveballs. And we're watching this play out in real time. And as exciting as it is, it's exhausting. And it's you know, because in the last 25 years, 2010 to 2025, so that's 15 years, we have had the Citizens United decision, then we had the Dobbs decision that overruled Roe versus Wade, and for the first time, I believe, took away a highly protected, strict scrutiny constitutional right of a woman's right to choose to determine whether or not to terminate her pregnancy, and undid that right in 2022. Then, from a regulatory standpoint, there was the case Loper-Bright in 2024, where the Supreme Court said that the judiciary has the power to interpret the regulations that govern the regulatory bodies, and the regulatory bodies are not going to be given the deference to interpret the regulations that have been drafted by Congress and passed into law. So taking away from the protection of a regulatory state where the regulators, the experts are the ones who sort of impose the regulatory standards by saying, no, the courts will determine how the regulations are interpreted. And the Chevron doctrine, which protected regulations and regulatory industry by giving deference to these regulatory agencies, will no longer have that that security of expertise and will be sent to the court of law to determine what those regulations mean, and come to the hands of judges like Emile Bove and Eileen Cannon. And then you have the Trump v. United States presidential immunity decision in 2024 that Judge Luttig quite arguably and correctly assumes is the worst Supreme Court decision in United States history. I believe so because it creates, on a constitutional level, it creates presidential immunity as a constitutional creature that does not exist in any part of the Constitution. So the implication made in prior dissents in Nixon administrations have come back, and they came back with a vengeance in talking about how the executive would have some sort of immunity. But here, the Roberts Court just goes into this, core presidential powers that are beyond the review of even the courts, and then an outer perimeter of immunity for official duties that are in this gray zone, therefore creating a lot of ambiguity in terms of what the limit of that presidential immunity is. And that is, I believe, the biggest overreach of the judiciary in giving the executive more power than was given by the Constitution or by any amendment to the Constitution. Many people will say, what about Dred Scott that said black people can't be citizens? Well, Dred Scott was in 1857, and it was overturned by the 13th and 14th Amendments. Then you have the Plessy versus Ferguson, that was 1896. So that's like 30 years apart, 40 years apart, nearly 40 years apart, where it said separate but equal is constitutional per the Equal Protection Clause. But that was overruled by Brown versus Board of Education. Then there's a Korematsu decision in 1944, which is looked upon as another really bad decision by the Supreme Court, where it upheld the constitutionality of the internment of Japanese Americans. And, on that note, the Civil Rights Act of 1988 granted reparations to people who were survivors of that internment process. And it was overly overruled in Trump v. Hawaii in 2018. Citizens United, Dobbs, Loper Bright, and Trump v. USA are laws of the land right now. And they've all happened in the space of 20 years. So, or 15 years. So the activism of the Roberts Court is really something remarkable, and I believe it will go down in history as being one of the darkest periods of our constitutional republic, the balance of checks and balances, and the overreaching powers of the executive and the supreme judiciary. Now, I don't know where they get this from. But I will end with one thing. I will end this by saying that Article 3 talks about the Supreme Court and the Chief Justice. And it says all other inferior courts will be legislatively created. And Article 3 branch courts are thereby legislatively created and assigned their constitutional role as Article 3 courts. The only argument that comes up that says where SCOTUS is the only court that matters goes to the unitary Supreme Justice and the Chief Justice, creating the presumption that only a case where the Chief Justice has signed and is the majority opinion is one that the other branches of government and the entire country have to follow. Or something even as extreme as the Chief Justice is the only one. You know, are we rolling towards that abyss where we are going to have an Imperator precedent and a Supreme Roberts Supreme Court that's going to reign over and tell us and tell Congress who and what the laws are and who they apply to, and we are just going to be left with those interpretations and enforcement. And then by this compliant Congress, which is the first branch of government, which has, like I said, the power to create these courts, the power to even disband these appellate courts, some of them, but that's not related here. But they do have that power theoretically, and you have this chaos within our constitutional system that you see brought on by the Roberts Court and the agenda of the Heritage Foundation and Leonard Leo's Federalist Society, and all of their, the MAGA QAnon engine was sort of the veneer on top of it, and then Donald Trump became the standard bearer of what we are seeing unfold, and the Supreme Court having laid the path to it constitutionally and politically and legally in a recession of our rights, a recession of safety, a reduction of government oversight on one side, but with overreaching executive power in Trump versus United States, and with these shadow docket decisions handing power to the Supreme Court and to Donald Trump, the unitary executive. This is a really messy situation, and I wanted to talk to you about it. You know, you can go and read all of these cases. You just look them up on Google. And the previous cases that I've talked about, the birthright citizenship cases, the employment cases, they are all in my playlists, so you can check them out. And the cases links are provided in those videos. This one, I'm just talking and giving you an idea of where ominous place that I find our judiciary and our republic to be in. You know, it's like, it's not compromised yet, but we are definitely dealing with more than one constitutional crisis. We are dealing with more than one existential crisis, and I hope that the American people can make it through what's coming and the police state that is being implemented by Donald Trump, now that he has been empowered by the judiciary and keeps getting empowered more and more by the judiciary, by the Supreme Court's shadow docket agenda. With that said, thank you so much for listening. Please like and subscribe, and I will talk to you soon.